Good evening, everyone. I hope everyone's doing really well this evening. My name is Alain Roussy. I'm the Interim Dean of the Common Law section at the Faculty of Law. I just want to take just a very quick moment to welcome all of you to this obviously very special edition of the Nelligan Moot this year. Thank you so much for joining us this evening. I want to thank obviously Nelligan for being a very special and important partner in this moot and for sponsoring this moot, and they've done so for many years now. And I also want to thank all of the judges who have been gave up many hours, including all of their Saturday, I think it was, to spend time judging this moot. Moots at the University of Ottawa are extremely important, as I'm sure most of you already know. It's something that we take great pride in, and we've had a lot of success in the last many years. And it's something that is very important as part of the law school experience for our students. So thank you to all the judges who make this possible. And thank you as well to Professor Stephen Blair and his team at the faculty for putting all of this together, including this year, obviously, because of this special environment that we're in, including our fabulous tech fellows who are making the tech work fabulously. So thanks to everyone. I hope you enjoy the evening, and I'll pass the baton to Professor Stephen Blair.
Thank you, Dean Roussy, and welcome everyone to tonight's championship hearing. I'm not going to speak very long, except to say again, thank you to everybody who participated in Saturday's preliminary rounds and playoff rounds, and that includes the participants and judges, and also to thank our technical people and the people at Nelligan who made the event work very well on Saturday, except for a slight delay in getting started, but we did make up that time over the course of the day. So all in all, it worked very well under the constraints we were under because of the pandemic. So tonight's championship hearing will be like ones we've held in the past, except it's online. It's being streamed live, and the same rules apply as did on Saturday. That is, each participant has 15 minutes to make their presentation, and appellants can reserve up to 2 minutes for reply if they wish. And the appellant counsel tonight are Elaine Tam and Gary Ballantham. The respondent counsel are Artem Shuska and Charlotte Wong LeBeau. They will introduce themselves, I'm sure, when they get up to speak. Our distinguished panel tonight, we have three very senior people from the city of Ottawa. Giovanna Raccomo. Giovanna Raccomo was a judge of the Ontario Superior Court of Justice. She retired a year or two ago and is now involved in arbitration practice. She has a very distinguished career as a judge, and before that, lots and lots of experience as a tort lawyer and of course doing other matters as well. Our next judge is Eric Williams. I now think he's retired or almost retired, but before that, he was the founder and head of the Williams law firm in Ottawa. Again, a litigation boutique firm. Long before that, that became a popular designation, and he carried on a very successful litigation practice, largely in the insurance defense area, but lots of other things too. And again, lots of experience in tort law, which of course is the focus of tonight's case. And our last judge is Pat Santini, and he's part of the Kelly Santini firm in Ottawa, and he has practiced law in Ottawa for many years now, over 35 years, and again, expert in tort law, has had cases at all levels of court. And again, all three of them, we couldn't ask for a better panel for the issues involved in tonight's case. So with that, I'd like to turn the matter now over to the panel, who will take control and get the hearing going.
we are going live right now. You can begin. I'm not sure whoever is starting can start now. Good luck.
Good evening, Justices. My name is Elaine Tam, and I, along with my co-counsel, Mr. Gary Ballaganthan, represent the City of Nelson as the appellant in the matter before this court today. Our submissions address the following 3 issues. First, I will address our main argument that the City of Nelson's snow clearing and removal on January 5th and 6th, 2015 were based on policy rather than operational decisions and are therefore immune from tort liability. Second, my co-counsel will address an alternative argument that had the City of Nelson owed a duty of care to the respondent, the standard of care was indeed met for a city of its size and needs. Third, my co-counsel will speak to the importance of adopting a broad conceptualization of policy in the context of the ongoing COVID-19 pandemic. We would like to reserve 2 minutes for rebuttal. Before I proceed, Justices, would you like me to summarize the facts of the case?
That's not necessary from my perspective, counsel.
Or from mine.
We've read the materials.
Thank you, Justices. Then I will proceed with our submissions.
May I ask Ms. Tam if you will be doing the reply?
The rebuttal will be with my co-counsel.
Okay, thank you.
Thank you. The main issue before the court today is the policy versus operational dichotomy. We put forth the argument that the city's snow clearing and removal actions were true policy decisions and as such are immune from tort liability. The distinction between policy and operational may be a fine one, but it is important. We are of the position that there are 2 main elements which distinguish a policy decision from an operational one. The first is that policy decisions are guided by social, economic, and political considerations, as discussed in R.V. Imperial Tobacco Canada Limited. The second element is that policy decisions are undergirded by overarching objectives to serve the better of the greater public good. By contrast, operational decisions flow from policy in that they pertain to their practical execution. And as such, operational decisions do not take into consideration social, economic, or political factors. And operational decisions are not born of a broader objective to contribute to the public good. So to illustrate an example of an operational decision, let's say that Ms. McDonald has a selection of shovels, and they are all of different sizes. If she has to make an operational decision about which shovel to use, her choice would be dictated by considerations such as the volume of snow, whether the snow is light and fluffy or more heavy and wet, whether the snow is more or less compacted, and so forth. So her choice of which shovel to use is an example of an operational decision because it is not driven by social, economic, or political considerations. Whether she chooses a short shovel with a narrow blade or a large shovel with a wide blade, her choice has no impact on her budget, nor does it change her overriding social goal of the actual clearing of snow. But on the other hand, if Ms. McDonald is making a policy decision, she needs to consider how and why the snow must be cleared and removed. So how should she clear the snow? Well, it's reasonable to say that given social considerations, she should perhaps follow a route through the city which prioritizes access to key public institutions, such as schools or the police station. And in doing so, she does need to remain within her economic constraints, given her limited personnel and equipment. And if we ask why she's clearing or removing snow, we understand that she is meeting the broader objective of public safety and mobility. In considering social factors, the city is responsible for plowing, sanding, and clearing 122 kilometers of roads, 21 kilometers of sidewalks, and 73 sets of staircases. Clearing just the 300 block of Baker Street takes 2 hours alone. So given the constraints and personnel and equipment, it is critical for the city to adhere to its policy of prioritization in snow removal. And even if this calls for a delay in removing windrows from Baker Street, Ms. McDonald should adhere to the priorities. Indeed, we would argue that the city acted reasonably on January 6th by first prioritizing the bus routes, City Hall, medical clinics, the fire hall, and the police station. We are of the opinion that ensuring public accessibility to medical clinics and emergency services should take precedence over a Subway restaurant. I would now like to invite the justices to join me at tab 7. That's tab 7, page 25. Here, we see the City of Nelson's streets and sidewalks snow clearing and removal policy. As its title suggests, this document is a statement of government policy, not of operation. The introduction states that, as a matter of policy, snow removal, sanding, and plowing of city streets shall be carried out on a priority schedule to best serve the public and accommodate emergency equipment within budget guidelines.
Council, I have a question. Are you suggesting that the city's choice of the term policy ends the inquiry as to whether it's a policy decision or an operational one?
Justice Santini, we are of the opinion that despite the policy being in the title, that does not necessarily imply that is a policy. However, in the introduction, it does state that the priority schedule is in order to best serve the public, hence the underlying objectives of social considerations, and it takes into account the budgetary constraints, which is the economic considerations. So it goes back to the framework which I had outlined before, in that policy decisions are guided by both social and economic considerations.
But in this case, the issue is the removal of the snowbanks, correct?
Yes, that's correct, Justice.
And the removal of the snowbanks isn't addressed except in a discretionary way in the policy itself. Do you agree with that?
Yes, that's correct, Justice Santini.
And when discretion is given to the snow removal crews to do something or not do something, you say that they're still carrying out a policy function or an operational function?
Justice Santini, as long as the decision is undergirded by social and economic considerations, we would deem that decision a policy decision. So despite this policy not specifically addressing the issue of windrows, that the unwritten policy does address the fact that Ms. McDonald, or when she was off duty, her delegated crew leader is able to make decisions to extend shift hours and to make other discretionary decisions based on social and economic considerations.
Okay, thank you.
Thank you, Justice Santini. After the introduction of the policy, we see that it proceeds to delineate a clear priority sequence of snow removal, starting with number 1, the emergency routes and the downtown core, and then number 2, the transit routes, and so forth. So by outlining a priority sequence, the city's policy is both reasonable and grounded in good faith because it permits the maximum number of the city's citizens to travel downtown to work and to shop.
May I ask where the 300 block fits into this priority?
Yes, Justice Rocomo, there are bus stops throughout the city, and there is one at the 400 block. And the bus moves towards the 500 block. So that is why the snow removal crews started by clearing the windrows from the 400 block first, and then proceeded to the 500 block. There are no bus stops in front of the 300 block, and that's why the windrow was left there to be removed later.
Thank you very much, Ms. Tam.
Thank you, Justice Rocomo. Now, with regards to the economic considerations, Ms. McDonald testified at trial that she simply could not use the entire year's budget in responding to the first snow event of the year, because it was impossible to predict how many snow events would occur thereafter. Remember, this snowfall occurred during the very first week of January. And in fact, Ms. McDonald testified that the city ultimately spent more than 20% of the entire year's budget for this one singular snowfall event. The fact that the city's snow removal costs fell under budget in previous years is irrelevant because weather patterns are highly uncertain and do not necessarily follow any general trend from year to year, especially given the dramatic effects of climate change in recent years. Thus, Ms. McDonald's decisions were significantly limited by both social considerations in ensuring that citizens had access to key public institutions and economic considerations of having to work within budgetary constraints. And as such, her decisions fall within the framework of government policy and not within the realm of the courts. Therefore, her decisions should be immune from tort liability. Now, before I invite my co-counsel to the stand, I would like to close with one final point. Case law has questioned the relevance of authority level in policy decisions. And indeed, in Imperial Tobacco, it mentions that employees working at an operational level are not generally involved in making policy choices. However, Just v. British Columbia provides further clarification. And I now invite the justices to join me at tab 8, page 31. Again, that's tab 8, page 31. And in the fourth paragraph on that page, I quote, "A true policy decision may be made at a lower level, provided that the government agency establishes that it was a reasonable decision in light of the surrounding circumstances." And Just goes on to say that while policy decisions are generally made by persons of a high level of authority, they may also properly be made by persons of a lower level of authority. So even though Ms. McDonald may be considered to occupy a position with a lower level of authority, Just indicates that she is indeed vested with the authority to make not only operational decisions, but also policy decisions. Subject to any further questions, I would now like to invite my co-counsel, Mr. Balaganthan, to the stand to discuss an alternative argument that had the City of Nelson owed a duty of care to the respondent, the standard of care was met. And then Mr. Balaganthan will proceed to discuss the importance of adopting a broad conceptualization of policy in the context of COVID-19. Thank you, Justices.
Thank you, Counsel.
Good evening, Justices.
Good evening.
First, if the courts in this case decide that the city owes a duty of care, the city still met the standard of care. The city of Nelson is a small municipality on the southern interior of British Columbia. It is constrained both by budgetary and personnel limitations in the services it provides. Due to these constraints, small municipalities like the city of Nelson rely on their own institutional knowledge and historical best practices in order to develop policies that best serve their citizens. In this case, the comparison of municipalities is irrelevant. Municipalities differ so much, from budgets to landscapes to urban planning to winding roads and the amount of snow they receive. The differences are so vast that it is difficult to compare their best practices. In fact, practices cannot inform standards. If we are comparing municipalities, how can we determine what an objective standard should be? What if we had a municipality whose best practice was to allow the snow to pile up in parking spaces only to be removed later? What makes this an objective standard? The city of Nelson met its obligation to serve the public after snowfall in two distinct acts. First, snow clearance, and then snow removal. In the snow clearance process, plows drive down the street, creating windrows as the snow is pushed against the curb. As my co-counsel detailed, this process is done in a priority sequence. Once the snow is cleared, crews then return using much of the same equipment to remove the snow. Standard of care in this case requires a priority schedule of first clearance, then removal. If the city does not clear the roads outside the downtown core prior to removing the snowbanks from the downtown core, the citizens of Nelson would be unable to travel downtown to work or shop. The city's standard of care is an obligation to the public and not to any particular individual or business. In evaluating the standard of care, it is important that municipalities are not liable for unfortunate and unforeseen consequences to any one individual while performing their duties to the public as a whole. Equipment, budgetary, and personnel limitations have to be factored into the standard of care where small municipalities are concerned. It can be accepted that the city owes the standard of care in the maintenance of roads and sidewalks. However, the access from the road to the sidewalk should be considered outside of the bounds of the standard of care because it is not pertinent to the city's objective of clearing and removing the snow in a safe and efficient manner. Our friends...
Can I just stop you? Do you agree that the standard of care is an objective standard?
Yes, Justice Santini, we agree that the standard of care is an objective standard. However, this objective standard should be evaluated on the needs and requirements of each individual municipality and should not be compared to one another.
But if we only compare it, if we don't compare it to any other municipality, does it not become a subjective standard? In which case then every municipality will be able to say, you can only judge us based on what we do and not based on what other people do.
Respectfully, Justice Santini, we disagree. And we disagree on the fact that it is an objective standard, and the objective is that decision is made on the basis of the citizens. That decision of whether the standard is objective or not is made in the ballot box and is not a matter for the courts.
Well, can the city's decision be reasonable if the city did not even consider the practice of comparable municipalities in its own practices and standards? The evidence that we have here is that it did not consider them.
Justice Rockamo, respectfully, we disagree. If I could refer you to tab 5, page 15, paragraph G.
Tab 5, page 15, paragraph.
G as in golf.
I'm unable to find that citation.
I can quote it for you, Justice Rothman.
I think you mean page 14. I think I have it here.
It would be referred to as
Oh.
the city.
Page 15, I believe.
Yeah, no, it's at
Correct.
the top. I found it. Go
Okay.
ahead.
The city does not remove or haul snow from the downtown core overnight due to noise complaints received in the past, as well as the cost of overtime. The city has considered the voice of the people. As a small municipality, the voice of noise complaints is representative of the voice of the people. With limited resources, this is not simply just a noise complaint that would be in a large municipality. In a small municipality, it represents a strong voice, a voice that should be considered and factored into how policy is developed, adapted, and changed. Our friends have stated in paragraph 21 of their written submission that Ms. Markey's decision to cross the windrow was a safer option when faced with the present alternative. However, this is simply incorrect. At the time of Ms. Markey's injury, there was a third present alternative. Ms. Markey could have easily parked on the 400 block of Baker Street. At this time, the snow had already been removed from the 400 block, and the parking was also available. There was also access to a sidewalk. Having to walk just one city block that was illuminated with streetlights, the 400 block of Baker Street was the safest of present alternatives. It would not have been unreasonable for Ms. Markey to walk just one block. If municipal governments are held liable for every injury resulting from every fall on a snowy day, this would open the floodgates to indeterminate liability. The standard of care is of reasonableness, not perfection. As discussed in Just, the courts have recognized the importance of government immunity from tort liability, provided that policy decisions are made in good faith and meet the standard of care. Stated is that the governmental agency should be entitled to demonstrate that it balanced against the nature and quantity of the risk involved, including budgetary limits, personnel, and equipment available. Here, the trial testimony of Ms. McDonald should be taken into account, where she clearly testified that the limitation of loaders, blade, and snowblower would have resulted in any worker being called in additionally having no equipment to use. The only available job would have been to clear the steps, and it is Ms. McDonald's belief that these workers would not have agreed to perform this duty as it was their regular day off. In meeting this balance, it is evident that within the available financial and personnel restrictions, the city met its standard of care. Additionally, it is our opinion that the Court of Appeal erred in its failure to consider whether the respondent was negligent. While the city is certainly sympathetic to Ms. Markey's injury, she has been a resident of the city for 28 years and was acutely aware of the dangers of winter. Well accustomed to her favorite Subway restaurant on Baker Street, the respondent's selection of her parking spot was dictated by convenience and not precaution. If we can take a step back, we can clearly see that Ms. Markey's injury actions are not the actions of a reasonable person. Despite noticing that the snowbank spanned the length of the block, she made no effort to drive just one city block eastward where the sidewalk was clear. She also failed to test whether the snow was tightly packed, but most revealing is her choice in footwear. We submit that a reasonable person in winter would be properly dressed for the severe weather after a snowfall. This includes wearing a coat, gloves, toque, and boots. Ms. Markey's choice of footwear being running shoes is not reasonable. We also submit that it is within reason to expect an individual to walk just one city block to access a restaurant. If her hunger had been such a pressing issue, she could have easily accessed a drive-through restaurant. In this case, we are not discussing an individual requiring immediate need for medication in a pharmacy or urgent care from a hospital. We are discussing a sandwich shop. Ms. Markey's decisions are simply a compounding of poor choices that led to accepting the risks of walking on a snowbank and ultimately being the unwitting architect of her own injury. It is paramount that this court not allow individuals to pursue litigation where they have created their own misfortune due to the consequences of opening itself up to limitless litigation and the message it gives to the greater public that individual responsibility is nullified. Our last submission is that the court should adopt a broad definition of policy in the name of public interest, especially in the context of COVID-19. The COVID-19 pandemic has reminded everyone of how fragile our most basic systems are in society, and with its impact on every aspect of society. It has also reinforced the need for a strengthening of public institutions and governments in order to effectively serve the people. Part of this strengthening is giving leeway to institutions to make decisions without fear of litigation when their decisions are well-intentioned and serve the best interest of the public. This is not just about the pandemic. It's about any outside force that influence how municipalities with limited budgets can make decisions, including severe weather events. The broadening of policy and thus immunity from tort liability allows municipalities to be better prepared to deal with the events that push the limitations of their budget and cause them to make tough choices when serving their citizens. As I conclude, I would like to remind the court what's at stake today. This case is not only just about windrows or the injury of one individual, but it is about ensuring that our public institutions and governments are able to effectively serve society and are empowered to take immediate action when required without fear of opening itself up to countless litigation claims and indeterminate liability. If we negate personal responsibility simply because one individual could not walk one city block, we risk every government service coming under attack, from snow clearing services to hospital intensive care units. We respectfully ask that this court reverse the decision from the Court of Appeal and not give rise to this consequence. Subject to any further questions, this concludes our submission. Thank you, Justices.
Thank you, counsel.
Thank you.
Good evening, Justices. My name is Charlotte Wong-LeBeau, and I am the opening counsel for the respondent, Ms. Taryn Joy Marchie. I will begin our presentation tonight by addressing the duty of care that the City of Nelson owed Ms. Marchie, following which my co-counsel, Mr. Artem Sushko, will address the city's breach in the standard of care and that Ms. Marchie was not contributorily negligent to her injury. Council would like to identify for the court the unwritten policies and policy decisions identified by the city and used by Justice McEwen in the original trial to find that the city's actions were insulated from liability for policy defense. You may find the list of these items on page 3 of our respondent factum, or a full list on page 14 of tab 5 of the appeal book. In particular, we would like to draw your attention to item D, which reads, when removing snow from the downtown core, crews first push snow into piles in the parking spots and then haul it out of downtown. My submission will address 3 points. First, the establishment of the duty of care. Second, the role of the written and unwritten policies. And third, the 2 operational decisions that are the basis of Ms. Marchie's valid claim in negligence against the city. Based on precedent, beginning with the duty of care, it is not controversial that the city of Nelson owed a prima facie duty of care to the respondent. As established and just in British Columbia, governments who undertake acts to prevent harm, such as under the snow clearing and removal policy, owe a duty of care to execute those acts in a manner that is non-negligent. This relationship between a government authority and its constituents is further identified in Cooper and Hobart as precluding the need to perform a full Ans-Cooper test in establishing the prima facie duty. In the Court of Appeal, Justice Wilcock furthered this conclusion by reference to Sullivan and Victoria City, in which a prima facie duty of care was established between a municipal government's sidewalk maintenance operations and an injured plaintiff. In reference to these precedents, we can establish the prima facie duty. The question of this appeal is that of policy versus operational decisions, which arises in the second stage of the Ans test, that the government should be protected from liability for policy considerations. The appellant claims that the snow removal process during the snow event of January 4th to 6th was a collection of policy decisions. Respectfully, the respondent disagrees. It is the respondent's position that the city should be held liable for 2 operational decisions made in the manner of executing the policy that resulted in Ms. Marchie's injury, for which she is now owed damages. The distinction between policy and operational decisions is a legally fraught topic. I invite the justices to find an accepted distinction between the 2 on tab 5, page 13 of the appeal book, taken from Brown and British Columbia. Brown and BC states that true policy decisions will usually be dictated by financial, economic, social, and political factors or constraints. Operational decisions, on the other hand, will usually be made on the basis of administrative direction, expert or professional opinion, technical standards, or general standards of reasonableness. It is the respondent's position that the decisions made during the snow event fall under the category of operational decisions as listed in Brown and BC. Under the streets and sidewalks snow clearing policy, the city lays out 5 priorities for plowing, sanding, and clearing. Contrary to the appellant's representation, the respondent does not refute that the prioritization of areas for snow removal is indeed a policy decision and insulated from liability. The decisions that were operational in nature, taken in the manner of executing those policy priorities and are subject to this appeal, are as follows. First, yes.
I have a question. The city has used the term policy in describing their document. Does anything turn on their use of that term?
Thank you for your question, Justice Santini. We submit that the simple designation of a government decision as policy is not sufficient to qualify it as policy. The mere assertion that a decision is policy has to be backed up by why the decision was made and the true policy purpose that it is made for. If, as explained by Ms. Tam in her submission, a decision was made based on the execution of the policy and was able to use discretion in the manner of executing that policy purpose, the decision is operational in nature and not based in policy. The respondent submits that the unwritten policies, in particular, do not qualify as true policy for those reasons. They are not informed by a true policy purpose, but rather are recommendations for the implementation of the true policy, as written in the snow clearing and removal policy.
Isn't that policy something that was decided upon by city council?
It is not submitted in the evidentiary record. whether those are truly decided by the city council, but the respondent would submit that even if they were decided by the city council or city actors, the government agents involved in snow clearing and removal were not using the unwritten policies in their application and execution of snow clearing and removal. This is evidenced by Karen McDonald's testimony, who seemed to lack knowledge of these policies during her testimony.
Thank you.
Thank you.
Eric Williams here. I just had a quick question. In R versus Imperial Tobacco, Madam Justice McLaughlin delivering the decision, she indicates at page 37 that the jurisprudence indicates that a test based simply on the exercise of government discretion is generally now viewed as too broad. Would that be your view? That in other words, there seems to be a review of the Supreme Court of Canada decisions, a narrowing of what is said to be too broad, i.e. policy decisions?
The respondent would agree with your statement, Justice Williams. As the role of government expands in everyday life and is more applicable to all of the decisions and practices and processes of everyday Canadian life, it is more important to be able to hold government actors accountable for operational decisions and negligence within those operational decisions that are made as the role of government proliferates through the realms of our lives.
Thank you.
Thank you. Continuing, the practice of creating windrows and the unwritten policies and policy decisions that were identified in the original trial. I will invite the justices back to tab 5, page 14, as I identified earlier, for the abridged list selected by Justice McEwen as relevant to this case. In particular, as I pointed out, item D states that the snow clearing of downtown should begin with pushing snow into parking spots for later removal. It should be noted that the operational decision in question, contrary to the appellant's submission, is not the removal of windrows, but rather the creation of windrows in the downtown core. As Justice Santini asked, we would submit that the unwritten policies and policy decisions do not qualify as true or core policy as identified in RV Imperial Tobacco. Rather, they were recommendations on how to implement the policy priorities of the true written policy. The assertion alone that a decision is policy is insufficient to develop the protection from liability. Policy decisions are typically exempt from liability in tort, whereas operational decisions that seek to implement or carry out a settled policy can be the basis for liability. Item D of the unwritten policies was presented to Ms. McDonald during her testimony as a reasonable alternative to the manner of executing the city's policy. When presented with this practice, she testified that it did not occur to her to remove snow in this way. This implies that the unwritten policies and policy decisions were not core or true as identified in Imperial Tobacco, but as I said, rather recommendations on how to execute the true policy. It should be noted further that in the alternative, even if we considered that the unwritten policies were true policy, the city failed to follow that policy by windrowing the downtown core rather than pushing the snow into parking spots first for later removal. Further, as identified as the first priority of the policy to remove snow and clear snow from the downtown core, there is no language in the written policy identifying how downtown plowing should be undertaken, aside from stipulating that it will take place in the early morning hours. The implication of the collection of facts that 1, unwritten policies exist as recommendations for the implementation of the true policy, and 2, that how downtown plowing is meant to proceed is not mentioned in the true policy, demonstrates that there is a requirement of discretion taken by the part of plowers and snow removal crew leaders in the manner of performing snow downtown plowing. As the Supreme Court held in Justin, BC, and in Ryan and Victoria, where there is discretion in the manner of executing a policy, the act is operational in nature and as such can be the basis for tortious liability.
Counsel,
Another point, yes.
Ms. McDonald gave evidence that the decision was based on economic considerations because this was the first snowfall of the year. Over a foot of snow had fallen and she spent 20% of the budget already. Since economic factors are one of the criteria that the courts look at in determining whether a decision is a policy decision, a core policy decision, or operational, what do you say about her consideration of the economic factors and how that affects the dichotomy between policy and operational functions?
Thank you for your question. Yes, it is true that Ms. McDonald made some budgetary considerations in choosing not to bring in extra workers or to extend the work hours. However, also by her own testimony, she testified that her decision was also based on her belief that the workers would not come in the given circumstances because they had been given days off. This is more reflective of a general standard of reasonableness or her own professional standards and expertise, which would fall under the category of operational decisions rather than policy. Further, the consideration of budget, as also laid out in Justin, BC, can be made in the process of making operational decisions. The mere consideration of budget is not sufficient to classify a decision as policy. It is informative, but not sufficient.
Thank you.
Thank you. Returning to the practice of windrowing, we would like to make one further point on this note. The city created a public expectation that parking may be restricted during the process of snow removal, particularly in the downtown core. In the public notice entitled 2014 to 2015 Winter Snow Program, the public was advised that parking may be restricted for snow removal operations. It was available to the city to restrict parking in the downtown core by pushing snow into piles for later removal rather than plowing and creating windrows for later removal. So the justices, the important point is this: by choosing at the operational level to create windrows rather than taking the reasonable alternative that was listed in their own unwritten principles, the appellant is able to be held liable for the injury eventually sustained by Ms. Marchi by crossing the windrow that the city created. I'll now move on to our second decision that is in contention. The respondent submits that it was operational in nature that Ms. McDonald did not extend the working hours of the snow removal crews overnight. As I mentioned, the policy decisions are typically grounded in social, economic, or political considerations. And RV Imperial Tobacco clarifies that those are usually made on a higher level. The role of Ms. McDonald was primarily operational, based in the execution of true policy. Tobacco gives us some guidance that operational actors who make operational decisions may make some form of budgetary considerations. However, it is by her own testimony that Ms. McDonald decided not to call in extra workers based on her own standards of reasonableness that workers would not come in from their days off. Importantly, these choices were operational in nature then and not based in true policy. It was an implementation of the policy and the discretion that the policy allowed to her. To summarize, the jurisprudence is clear that governments who undertake an act based in a policy have a duty to execute those acts non-negligently. The decision to plow the downtown core by creating block-long windrows rather than plowing snow and pushing it into parking spots for later removal is not founded in any core policy. Further, the decision not to extend work crew hours and the decision not to call in extra available workers were also operational in nature. The appellant's duty of care, therefore, has not been discharged by their assertion of a policy defense. Barring any further questions, I thank you for your attention, and I'll turn it over to my co-counsel, Mr. Artem Sushko, who will discuss how the city breached the standard of care that it owed the respondent.
Thank you.
Thank you, counsel.
Good evening, Justices. Thank you for taking the time to hear our arguments. And thank you, co-counsel, Ms. Wong-LeBeau, for establishing a duty of care. However, it is necessary to address the breach in standard of care and causation before negligence is proven. To that end, I will answer 3 questions. How did the city breach its standard of care? Did the city cause the harm by breaching its standard of care? And was Ms. Marchi contributorily negligent? Before answering the first question, it is important to note that adhering to a statute does not in and of itself preclude a finding of civil liability. A party authorized to create a risk in complying with authority can be held liable for failing to minimize the risk of the hazard created by their preferred choice of execution. This principle was established in Ryan and City of Victoria. Appellant counsel contended that they met the standard of care in following the Nelson City snow clearing policy, and that asking anything more would be a standard of perfection. This, however, is not the issue. Justices, it is not controversial that the standard of care in tort is that of an objectively reasonable person in the circumstances. Ms. McDonald and the shift leader could have objectively reasonably foreseen the risk of harm coming to one of their citizens in creating the windrows along Baker Street. The windrows measured approximately 60 centimeters high, 1 meter wide, and extended the length of the street and had no cleared paths to the street. This barred access to anyone who had tried to access it from street side parking. Counsel for the respondent will demonstrate 3 reasonable actions that could have been taken to minimize the risk, and prove that in failing to do any of them, the city breached its standard of care. First, the city could have extended the night shift on the evening of January 5th. 1 or 2 members of their crew could have cleared small pathways intermittently through the windrow in allowing street side access. Second, they could have moved the windrows into parking spots for later removal. Our friends argue that the practices of other neighboring cities are irrelevant to the city of Nelson, as was questioned by justices earlier. Counsel for the respondent respectively disagrees with this view. The objective reasonable standard is informed by how other reasonable persons act in similar situations. Furthermore, the city has a similar practice of pushing snow into parking lots instead of creating windrows, as Ms. McDonald testified to not being aware of. If the objectively reasonable standard could not be informed by what other people would do, as was questioned, how could it be objectively reasonable?
Counsel, you referred to the issue of how the city of Nelson would react in similar situations. Isn't that where
Yes.
the comparison with the other municipalities comes in?
Yes, Your Honor. The municipalities are considerably similar in that they occupy neighboring regions. They both suffer similar weather conditions, and it is reasonable to look at the practices of other neighboring cities to inform their own. But
What
even
about
if we were to,
What about the economic dissimilarities between cities? Does that play a role here in achieving an objective standard of care?
it is, and to your point, it is important because all 3 of the alternative actions, which I will propose, which were forgoed, had a low cost and were readily available, but not utilized. Counsel for the appellant demonstrated and stated in their factum that the city of Nelson was under budget for 3 consecutive years leading up to the snow event. And this snow event was not out of the norm for the city of Nelson. On that basis, it is not reasonable to assume that extending shift by an hour or 2 or creating notification of restriction to the parking space through the form of a sign or pylons would have been prohibitively expensive or materially affected the budget.
But not every year is the same. And on this weather day, the city of Nelson spent 20% of its budget at the beginning of the year. What do you say about that? Your friend takes the position that they should be judged based on their own actions as opposed to comparing them to other cities where not all the factors are the same. What do you say about that?
I respectfully disagree with counsel for the appellants, Justice Santini. A reasonable objective standard can't be established without comparison. Otherwise, every individual municipality across Canada would be held to their own standards. And having no baseline, there is no question to what objectivity could be.
Thank you.
Thank you. Continuing, the last action the city could have taken would be restricting access to street side parking where woodrows had been cleared in the form of a sign or pylon. This was actually indicated that it could be utilized by the 2014 to 2015 snow removal notice. It would be reasonable to expect citizens to interpret this notice as having access to parking spots reasonably if the city did not restrict them. If we cannot make this assumption, then it would serve no purpose for the city to create notices if they did not believe that their citizens adhered to them or even considered them as reasonable. In addressing the second question, did the city cause the harm by breaching its standard of care? We contend that it did. Counsel for the appellants stated that Ms. Marchi was the sole and proximate cause of her injury. This argument echoes the proximate cause analysis from Robson and Spence, which implies that the law recognizes only one cause. As quoted by the Honorable Justice Wilcock, for the record, it can be found on paragraph 27 on page 10 of tab 3 in the Appellant book, but you don't have to look there now. This is the wrong test, as causation in the law of tort does not require the cause which led to the harm to be the sole cause or even the most significant cause. Only it need be a cause of the injury. The correct test would therefore be the but-for test, as reaffirmed by this court in Clemens and Clemens in 2012. By applying this test, the court can see that but for the window making the street inaccessible, Ms. Marchi would not have fallen through the snow and popped her knee. It is not unreasonable to hold the city liable because their negligence caused the injury in fact and in law. It was reasonably foreseeable that commuting citizens will park where parking is available and try to access the street, especially on Baker Street, which is the main commercial street in the city of Nelson. Furthermore, it is not necessary to show that the precise injury or the full extent of the injury was reasonably foreseeable, only that the type or kind of injury was reasonably foreseeable. It was reasonably foreseeable that a citizen of Nelson could come to physical harm in crossing the large woodrows created, which extended the full length of the street. Finally, I will address, was Ms. Marchi contributorily negligent? Counsel for the appellant made 2 points on this. Originally, they said that Ms. Marchi could have parked a block over and walked to her destination. This is ideal, but it is purely speculative. Available parking is limited in a city core on major commercial intersections such as Baker Street, especially after a snowfall. A reasonable person in this situation would not assume that there were multiple parking spots available and waiting for them. Ms. Marchi acted reasonably in parking in the only spot she saw available. Furthermore, in the 2015 snow removal notice, the city indicated to its citizens that parking may be restricted for snow removal. This created a reasonable expectation that spots which were not restricted were okay to park in. The facts did not lead credence to the fact that there were parking spots anywhere else, and this was agreed to by both counsels at the trial and appellant levels. Furthermore, counsel for the appellant also takes issue with the shoes Ms. Marchi wore, claiming that should she have saw the risk of losing traction, this may have changed her choice of footwear and prevented the accident. This is not the issue. The streets were dry and Ms. Marchi did not slip. The issue here is that her foot got caught in the snow when it fell through, just as it had for Jason Johnson, the bystander who came to help her. the facts do not support that alternative footwear would have prevented this particular problem. Lastly, counsel for the appellant argued that Ms. Marchi failed to test the snow, which made her contributorily negligent. Testimony from the trial does not support this claim. Ms. Marchi had explained that she examined the snow beforehand, seeing footsteps, and assumed someone had reasonably crossed the woodrow. Further, she tried to step slowly and carefully. However, her foot fell through the snow instantly. Counsel for the respondent does not argue that Ms. Marchi acted perfectly. However, the standard is not of perfection, but of reasonableness. And Ms. Marchi acted reasonably as a city dweller in her circumstances would. For the foregoing reasons, I respectfully request that this court find in favor of the respondent, dismissing the appeal and granting relief as the honorable court deems just. In the interest of justice, it is important that citizens have access to recourse when their city fails their duty to them. The decision reached here today will affect a whole class of citizens across Canada by sending a signal as to what they can expect of their local governments. I ask this: do we want to tell them that governments do not owe their citizens a duty if they use the magic words of policy, or that they could disregard that policy when it exists? Thank you.
Thank you, Mr. Schaefer.
Thank you.
Your counsel.
Justices, on rebuttal, we would like to bring up two key points to identify. Our respondent has identified multiple times to the unwritten policies stated on tab 5, page 14, in specific reference to paragraph D, as in Delta. If you could just give me a signal when you're there. I would like to highlight two key items here. First, paragraph 4 is the starting point is the city's streets and sidewalks snow clearing and removal policy. If we refer to paragraph D, it states, and I quote, when removing snow from the downtown core, crews first push snow into piles in the parking spots and then haul it out of downtown. The existence of a windrow is not the step of removing snow, but it is only occurring by clearing snow. What would happen after the crews have cleared the outside of the downtown core is that they would return, pushing the windrow into the available parking spots, effectively restricting them, and then hauling them into loaders and removing them, as the policy clearly states. The respondent here has mischaracterized the policy. It is clearly stated, and they have referenced to it multiple times. In addition, they've cited Ms. McDonald's testimony that this removal policy of letting the snow pile up did not occur to her. But this is not the issue in question. The issue in question is whether clearance was properly done so. This concludes our submissions. Thank you very much for your time, Justices.
Thank you.
Thank you, counsel.
Thank you, everyone. Now the judge will provide the participant with initial feedback. This will be followed by the judge spending a few minutes to deliberate. I now invite the judges to give feedbacks to the teams.
Mr. Chair.
Well, Mr. Williams?
Yes. I would be stating things too broadly if I didn't say that I thought all of these submissions were very well done. I thought that the openings were good, the questions were good, the statement of what they were going to argue was good, and virtually every one of you answered questions very, very well from the bench. You didn't try to fluff it off, you answered the question directly, and that's the point of view of good counsel. You're obviously very well prepared also. I can see that you've scoured the material, you know the facts backwards, you know the differential between the cases, and you also know what the differential is between a Court of Appeal case, Supreme Court of Canada case, and the trial judge's cases. So some would not refer to the facts in the trial judge's decision, probably because they've been overturned by the Court of Appeal. I thought it was just very, very well done from my point of view.
I would agree with my friend, Justice Williams, and would add that I felt your organization of the arguments on both sides was very helpful in that you provided a very clear path of where you were going for us and followed that path without fail. So I commend you for that.
And just to add my 2 cents, I'm thinking back as I'm listening to you to my moot court experience. I wasn't that good then. I'm not sure I'm that good now. So congratulations. You've done very, very well. You know, one of the major differences between doing appeal type work, such as you're doing in trial work, is that the judges on the appeal court are not afraid to ask questions. So when we first met, because of the time constraints, we thought, we probably shouldn't ask any questions, but then it wouldn't be fair to you or to us in assessing you not to ask you any questions, because it's a real test to know how to answer the questions and then get back on the horse without it affecting your presentation. I thought you were all excellent in the way that you introduced the topics and the way that you presented your evidence. So congratulations to all of you. Well done.
Thank you. I now invite the participants to leave the Zoom and go to the link that I'm adding to the chat right now. That is a live stream link. The judges will take 15-minute break to deliberate.
Thank you.
Thank you very much, Justices.
Thank you very much for your time, Justices.
Thank you. Yes.
There are moments in life that can't be left to chance. In these times, everyone needs counsel. At Nelligan Law, our mission is to simplify the legal journey and be with you every step of the way. So when you need a guide for life's pivotal moments, call us. Our profession is the law. Our product is peace of mind. Nelligan Law.
career is important to me, but I'm suffering alone. I spoke about it, but now I think I might lose my job. They look at me differently. I hear them talk. I'm the one who feels guilty. Is it my fault? I feel like I'm fading. Your work life should always be safe and inclusive. We hope you never have to call us, but if you do, we're here.
Okay, well, welcome everyone to our last aspect of this year's moot, which is the award ceremony following tonight's competition. I'd like to congratulate the council tonight, who all did a very, very fine job. I was party to the discussions which took place, and I can tell you that a very difficult decision for the judges to make, although they were very swift in making their decision. So on that basis, and this is the schedule I have, and I hope Janice is online now.
Here, can you hear me?
Yes.
Okay, the lighting is
Good evening,
interesting.
Janice. My schedule says that I'm supposed to introduce you as the, I guess now senior partner at the law firm of Nelligan O'Brien Payne. Janice is a graduate of this law school. After law school, she articled at the Nelligan law firm and has been there ever since. She is a expert in the area of employment law, a province-wide reputation in that area of law. And she's just going to say a few words of introduction at this point in time.
Thank you very much, Professor Blair. I'm sorry about the lighting here, and I'm sorry I look so sparkly. But thank you. I'd like to add my own words of welcome to everyone to the awards presentation for the 2021 Nelligan Law First Year Moot. I want to thank, first of all, of course, the three judges we had tonight. It was wonderful that they were able to give us their time. Justices Rocamo, Williams, and Santini, thank you very much. Thank you as well to the members of Professor Blair, of course, and the other members of faculty involved in this effort, all of the lawyers and judges who assisted on Saturday, the students who participated on Saturday, and to everyone who contributed to our ability to offer the first year moot this year. We missed it last year due to COVID, and we're really sad to miss it for the first year, I think, in 13 years. So we were just delighted to have the opportunity to do it again this year, albeit virtually. And while I have said that I would have been much happier to do all of these sessions in person, there was a silver lining. We were able to attract some very interesting judges on Saturday, not just from outside of Ottawa in Ontario, but across the country, and even one from London, England, people who we would never have been able to involve in the moot before. So that was exciting, I think, for the students. And of course, this is the way of the future. This is the way lawyers are going to be arguing their cases, at least some of the time. The departure of COVID is not going to bring an end to some remote work in advocacy. In-person advocacy isn't going to disappear, but some matters, including appeals, will be argued this way. And so we all need to learn new skills, including the students in school today and ourselves. Every year, the lawyers involved in putting on this moot leave just amazed at what first-year students can do when they get on their feet after only 2 months in law school. And this year was no exception. All of the students who are participated on Saturday are to be congratulated for stepping up and taking a turn, and so many of them did very well. It was hard to choose the semifinalists and even harder to choose the finalists, but boy, we did well with our finalists today. I think it is rare that we've seen such even skill sets across all four. It was a delight to watch them all. We hope that many of you now have the bug and will go forward to more moot court competitions and, more importantly, to a career in advocacy. So congratulations to every one of you, and congratulations to all four of the participants tonight. I'll stop now and hand things back to Professor Blair.
So the next order item on the agenda is, before we get to the awards tonight for the oralists, is to deal with the matter of the best factum. And there were several factums submitted by the morning round judges on Saturday. And I should note that the prize for the best factum is awarded by the County of Carleton Law Association, or CCLA. And it's actually quite a valuable prize, because the winners get to go to the upcoming Solicitors Conference, which is held every May, sponsored by the CCLA. It's a 2-day conference, and it attracts hundreds of lawyers from the city of Ottawa and surrounding area. And in pre-pandemic times, it was held at the Chateau Montebello, which is quite a nice place to visit, about 40 miles east of Ottawa. I don't know whether the spring of 2022 conference will be in person or whether it will be online, but in any event, the tradition continues. So you get free passage to that conference, which is an opportunity to sit in on the program and meet many lawyers who are in practice in Ottawa, which is very valuable to you from a career point of view. That's the free part, but it also includes a work part, because the tradition is that the students who wrote the winning factum, what they must do is turn their factum into a conference paper, and the paper gets presented at the Solicitors Conference. And so this is an opportunity to get up in front of a group of lawyers and do a presentation. And certainly it's an interesting topic this year, because even though it's arguably a litigation point, it's also important for solicitors to understand the liability issues that surround the municipalities these days. So they will find this year's topic very interesting. So it is a big prize, it's a big commitment, but well worthwhile, and something to think about over the next few months, how you're going to turn your factum into a paper that will be published. So on that basis, what I'm going to do is just mention the candidates for best factum, and then I will announce the winner. And so. And this is in no particular order, but we had, I'll just start here. The team R15 factum, Alex Sokolov and Natalie Gasons. The R29 factum, team 29, our respondent 29, Sarah Rowe and Robin Dusemi. The R31 factum, Michelle Lau and Amy Watson. The A36 factum, it's Meyer Shanine and Tiffany Wu. The R38 factum, Jonathan Labianco and Kachi Wong. The R9 factum, Sarah Sevier and Megan Jenkins. And the R14 factum, Arten Chusko and Charlotte LeBeau, who appeared tonight at tonight's hearing. So what's up for award then is the Best Factum Award and the corresponding CCLA prize. And those of you who don't succeed on the best factum prize, you receive honorable mention based on the quality of the factum that you did submit. So without any more delay, then I can announce that the winner of this year's Best Factum Award is Team A36, Meyer Shannon and Tiffany Wu. So congratulations, Meyer and Tiffany, and you can start planning your presentation at the conference this coming May of 2022. But you can probably take the night off. You don't have to worry about that. So congratulations again, and congratulations to everyone. We had more factums than normal that are submitted this year. We had 7 factums in total, and the comments made by our evaluators were all quite good. So congratulations to everyone. Now, I'd like to at this point then introduce Erin Lepine from the Nelligan firm. And Erin is a partner in the firm, and she is going to present the John P. Nelligan Cup to the top 2-person team in the competition. So one of the 2 teams tonight, it will be awarded that cup, and I expect she'll also have a few words to say about the person after whom the cup is named, Mr. Nelligan.
Yes, sorry, thank you. And thank you so much for having me this evening. It's an absolute pleasure. So John Nelligan was one of the founders of our firm back in 1969. And over his lengthy legal career, Mr. Nelligan was particularly well known for having an incredible presence in the courtroom. Mr. Nelligan was a type of advocate that we all strive to be. He was passionate about working with young lawyers and law students, and this included taking part in this first-year moot court competition, right up until he simply couldn't do so any longer. Our firm continues to share Mr. Nelligan's commitment to building strong advocacy skills in young lawyers and law students, and it is with absolute pleasure that I get to announce that the winning team of this year's Nelligan Cup is Team R14, Artem Sushko and Charlotte Wong LeBeau. Congratulations. Everybody tonight was incredible. You should all be very proud of yourselves.
Thank you, Erin. And I should add, my comment, which of course is that until very recently, Mr. Nelligan used to come to these competitions, and he would speak every year. He would speak passionately about advocacy, as Erin indicated. And I remember one year I was speaking to him before the presentation, and I said to him, well, sir, you've been doing this for 50 years now, over 50 years. And of course, he quickly corrected me, pointing out that it was well over 60 years at that point in time that he had been practicing law and still going to court. So he went to court, I would say, well into his 80s, if not perhaps a bit later. Maybe Janice would have some information about that. But in any event, it was a great loss to lose him and not have him come and speak to you every evening, but certainly his spirit lives on in the continuance of this competition and the awarding of the company's name. So on that basis, then I'd like to turn the floor over again to Janice Payne, who's going to speak about the new award this year, the Al O'Brien Award for the top advocate in the competition.
I'd be pleased to do that. Now, I think, Professor Blair, you were going to also share some comments about this award, but you've invited me to go.
Okay.
Do you want to speak first?
Yes, I'll speak first, of course. Yes.
Okay, all right. Because you were close to Al, and I mean, I think we both were, of course, and so we wanted to do this together.
Well, Al O'Brien, he graduated from this law school in 1973, and he told me this story many times, and I'm not sure. I still can't remember now what the correct version is, but he spent most of his time at law school, at University of Ottawa Law School, before Photo Hall opened. And perhaps he spent his whole time at Photo Hall before it opened. Janice might know the answer here.
Yeah, whole time.
Whole time, okay, because the carving outside the building says 1973, and that's the year Al graduated. So presumably the law school opened that fall, and I mean the new building, the then new building, now the older Photo building, opened. So he never went to school in this building, but nevertheless, he was probably the most loyal alumnus this school has ever known. He just he loved his time here. He loved the law school. He just contributed to it in so many ways after he graduated, and of course he was a major presence in the Nelligan firm, like Janice. He articled at the Nelligan firm, and he worked there from that point onward. So he never worked anywhere else for, well, I'm going to say over 50 years. So it really was a remarkable career that he had. And unfortunately, he passed away earlier this year. And we still, the Ottawa Bar, feel very sad about that. We miss him greatly. We miss in the bar, but also at the law school, and in particular tonight in this competition, because he was such a driving force in getting the competition up and running, and he was here every year and happy to be here and contributed to it in so many ways. So on that basis, I'll turn it over to Janice, of course, who knew Al so well.
Thank you. Thank you very much. This is, of course, the first year. It's not the first year we've presented the award for the top advocate, but it's the first year that the award has now been named the Alan R. O'Brien Award for the top advocate in the final of the first year moot. Al O'Brien and I practiced law together. I was 1 year behind him in this law school, and so that's why I was so sure. I spent only 1 year at Photo Hall, and I was pretty sure he wasn't there at all. He and I practiced law together for 45 years. He died in April of this year, and I am still not used to it. I think it will take many of us a long time to become used to it. We keep expecting him to show up. It's so hard to believe that he's gone. From the beginning, Al was an enthusiastic proponent and participant in the first year moot at Ottawa U. That's absolutely right. After his sudden death in April of this year, Professor Blair suggested to me that it would be a good idea to name the top advocate award after him. And I checked with his family and with the firm, and of course we all immediately agreed. It's wonderful to have something to offer in his honor when he can't be with us any longer. So let me just see if there's anything. I know that he would be delighted tonight to see that award is being presented to this year's winner. And even more delighted to know that this year's winner is Charlotte Wong LeBeau. Congratulations. Really well done. We're very proud of you. And very proud, frankly, of all four of you tonight. I said it a moment ago, but I don't think I've ever seen two teams so evenly balanced and so well prepared. You were a pleasure to watch, an inspiration to all of us. And we can't wait to see what you're going to do next. Well done.
Okay, well, that just about concludes our proceedings tonight. Now, in past years, we met upstairs in the third floor lounge, and there was a bar set up, if you can believe it, and even a free drink card or a ticket for everyone who attended the award ceremony. So we're not offering that this year. So things will end much sooner. And of course, there was the opportunity to meet with the various lawyers from the Nelligan firm who were present at the award ceremony, and others, and the judges as well, and chat with them for a while. And we're missing out on that this year too. But maybe by next year we'll be back in person. So again, I wanted to thank Janice and her firm for their tremendous support of this event, and their support in getting it running this year on a sort of an online Zoom basis. I think we're pleased with how that turned out. We weren't quite sure until we did it that it would work, and I think that it's not quite the same as in-person advocacy, but it's a pretty good substitute. And on the last point, I did want to say, and I participated in many of the deliberations over the years in terms of selecting the winners of tonight's competition, and I agree with Janice. I don't think it's ever been a case where both teams have been so closely matched in terms of their presentations, and all four speakers tonight did very well. So congratulations to everyone. And with that, I think that concludes the evening. Thank you very much for attending.
There are moments in life that can't be left to chance. In these times, everyone needs counsel. At Nelligan Law, our mission is to simplify the legal journey and be with you every step of the way. So when you need a guide for life's pivotal moments, call us. Our profession is the law. Our product is peace of mind. Nelligan Law.